scariest part is that you go to the clerk magistrate hearing or the district court, they have rules of evidence, rules of procedure, right? Even in immigration court, you know what you can and you can't do. And they have checks and balances in terms of who's hearing evidence, who's deciding on the credibility of the evidence. People have constitutional rights, right to an attorney, right to cross-examine. And when it comes to schools, that all goes out the window. It's literally just whatever they want. And they try to come up with guidelines and handbooks, but at the end of the day, it's just kind of however they do it.
Welcome to episode 12 of the Boston Barristers. I am Matthew Peterson. I'm here with Bill Manchinton. How's it going, Bill?
Excellent. Very excited for another episode of the Boston Barristers. I know we got a great topic today.
Yeah, so today we're going to talk about students. And Boston is a college town. I think there are how many colleges in the Boston area? Something like 500, I think.
I didn't go to Harvard, so I can't do the math on that one.
And I feel like college was just a couple of years ago for me, but then I realized it's like over a decade ago. It's something like 14 or 15.
It feels just a few years ago for me. It doesn't feel like that for me because anything pre-COVID feels like a long time ago.
Yeah, but we're getting the gray around the temples. We're not students anymore.
I got it. Yeah. I have gray. Yeah. Yeah. I mean, I think I got some gray during law school because of law school.
Yeah. But, I feel like most of mine is because of my kids. But
yeah.
And the lawyers that I have to deal with on a daily basis at my work,
Eesh, I know. Chris O'Brien. Brutal.
Oh, man. I think, yeah. So anyway, we're going to talk about, we have a lot of kids, Boston area college kids who come here from out of town, and they might make some bad decisions, right? So they might get in trouble. And we're going to talk about like all the different things that you have to worry about if you're a college kid and you get in trouble.
Your brain hasn't fully developed yet, right? You're not 25 yet. You think you got everything figured out. Newsflash, you don't.
Yeah, I don't even know when does the brain fully develop? What's the science on that nowadays?
I think that the commonly held opinion is 25 years old. That's what I see on the memes. So I think it's 25.
I mean, you can always trust what the latest Facebook memes have to say, right?
Absolutely.
Absolutely. We want to talk about the kind of triple whammy that especially the international college student faces if they get in trouble, and how it could affect both. You got the criminal charges, the potential of criminal charges. You have the immigration consequences, but then you also have the student discipline consequences, which kind of all three feed back into each other. The results of the student discipline could affect your immigration. Results of the criminal case could affect both of them. So there's a lot going on with students, and we want to kind of break it down for all the college kids in the area. So let's say you're, college kid, you're going to, one of our great schools, best schools in the country here in the Boston area, and you get in trouble. First thing you kind of have to worry about is a criminal case. So for a college student who, we get these calls all the time. People say, yeah, I got caught by the police doing this, and they told me I would get something in the mail. What does that mean? So if they say we're going to get something in the mail, what does that generally mean for a college kid, Bill?
Well, I can tell you that probably the most common case for the college kids who come to us is that, they go to a liquor store and they get their fake ID taken by the clerk at the liquor store. And the clerk says I'm just going to take it away. Not going to call the cops. It's all good. And then what happens is, 3 months later, 6 months later, those IDs that got taken away, they actually get given to the police. Then the police send that thing in the mail. That thing in the mail is a notice to appear at a clerk magistrate's hearing. And what that piece of paper says is you need to show up to court on this day and this time because we're going to question you about this fake ID. Now, that's the bad news, that you got to show up to court. The good news is that you're not going straight to an arraignment for a criminal case and you're not being entered into the criminal justice system. You are being given an opportunity to defend yourself before the complaint or the criminal charge even issues. So it's at this sort of liminal space where it's not official criminal charge yet, but they're asking you about it. And we've covered this a little bit in our other podcast, but at a clerk magistrate hearing, what they're trying to do.
We had a whole podcast about clerk magistrates hearing that you and I did, right?
Yes, is they're trying to see if there's probable cause to issue the charge. And so the students will be appearing at the clerk magistrate hearings, and there will be a determination as to whether or not there's probable cause to issue the charge.
So, yeah. So a lot of times, even if you hear an officer, like in your case, where you get these all, like you've represented so many people with these, and basically there are officers with the Boston Police Department who go around to these liquor stores, get the IDs, and they'll summons all these people, try to figure out who they are, and they'll summons them. Right. But you also have other circumstances. And we did a whole podcast on clerk magistrates hearings that you should go and watch if you don't know what they are, which I think was episode 1, wasn't it? Jazz, was that episode 1 or episode 2? Either way. So you have clerk magistrates hearings, fake ID. That's one type of thing. Mm-hmm. You also, like, if you say somebody gets into a bar fight and officers respond, no one gets arrested, but they say you're going to get something in the mail. It could be a clerk magistrate's hearing, but it could be an arraignment. Yep. Right. So what's the difference there?
Yeah. So as I was talking about the clerk magistrate hearing, that is a hearing to determine if they want to go ahead and press charges and put you in the official system. If you get summons for an arraignment, that decision's been made. They're putting you in the criminal justice system. You are charged and you now have a criminal record. And so what the arraignment is when you stand before the judge and they read the charges against you. You are here today because you're being charged with XYZ crime.
So hold on. Yep. Are you, Bill Manchinton, telling me that if you get a summons for an arraignment that it's definitely going on your record? Because I know for a fact that's a lie. Because I know for a fact that Bill Manchinton has prevented that from happening.
Well, in rare cases, right? In rare cases, you will go for the arraignment. You'll be summoned for the arraignment. And if you have a great attorney, sometimes they can pause that arraignment. They can either do one of two things. They can push the arraignment off and reschedule it for a later date to see if something can be worked out, or the case just goes away. Or there is pre-arraignment diversion. And speaking about the international students, this is essential. This is key, very important to know. Because I had a client who was accused of larceny, of stealing from a Target. And this person was an international student. And I knew that if they were arraigned, that record of the larceny charge would be on their criminal record.
Yeah.
However, if they are not arraigned and the case goes away before arraignment, it doesn't show up on their record. So the morning when my client was to be arraigned, I went and spoke to the prosecutor, actually the prosecutor's supervisor, and said, hey, like, you need to understand this situation. I pulled a Karen, like the line prosecutor.
I think you and Chris talked about this a couple of weeks ago.
Yeah. So, pulled the Karen and was like, hey, like, there is context you need to understand here. The allegation is, $50 in value, and you're going to ruin this kid's career if you arraign him. And we were able to just get a deal for some community service.
Yeah.
So he would avoid the arraignment and be able to graduate and go to a job. He had an amazing job lined up, right? This was someone who checked every box, straight A student, graduate student, going to get a job at a Fortune 500. It's actually one of the top 5 companies in the world he has a job for. But for whatever reason was caught up, alleged to have stolen, pocket change amount of goods at a Target, had all of that on the line, was risking all of that. And we were able to have him avoid any consequences by making sure it was dropped pre-arraignment.
Yeah, and that's what a lot of times, like, imagine if that guy, because I heard you and Chris talking about this in episode 7, Jazz just put in the notes, which is the stages of criminal trial, you talking about this. And I've sat there in arraignment sessions and seen so many attorneys, people just walk in and they get something in the mail and they call the clerk's office and like, yeah, they'll appoint you an attorney. And they get there, their appointed attorney doesn't think about the fact that, hey, maybe I could avoid this arraignment. They just pick a new date, but the damage has already been done. That arraignment is now on their record. And,
right.
That's why as soon as you get that thing in the mail, even if it is an arraignment, you got to call a lawyer and figure out, hey, how can we fight this now? And I've done the same thing plenty of times too, where, I've even had clerks hearings that didn't go our way, where we're able to talk to the prosecutor before the hearing and get it squashed before an arraignment even happens. So yeah, you have the clerk magistrate's hearing and the arraignment. You and Chris have, talked a lot about in episode 7, the stage of the criminal trial. And I don't want to go over that. If anyone who wants to know can go back and look at that.
Right.
Today's episode is brought to you by the Law Office of Matthew W. Peterson. If you're facing legal trouble in Massachusetts, whether it's an OUI, a firearm charge, or even just a clerk magistrate hearing, the stakes couldn't be higher. This isn't the time to go at it alone. You need more than just a lawyer. You need a legal team that knows how to fight and knows how to win. That's why people across Massachusetts turn to the Law Office of Matthew W. Peterson. With years of experience in criminal defense, family law, and immigration, we've got the track record and the passion to defend your rights. We've successfully represented clients in some of the toughest situations out there, from first-time offenses to serious felony charges. We've helped people protect their record, their families, and their freedom. So don't wait until it's too late. Visit mwpetersonlaw.com to schedule your consultation or call 617-295-7500. That's mwpetersonlaw.com and 617-295-7500. Because when your future's on the line, you deserve a legal team that's all in. Stay informed, stay legal. Now, back to the show. So what are some of the ways, so college student, if they get a criminal case, let's say they get past the arraignment, what are some of the ways they can get a case cleared off of their record?
So do you mean expungement, or are you talking about
like anything like expungement, sealing, like a not guilty verdict, dismissal, just for let's give a bird's eye view for the college kid who gets this in the mail and thinks, I get these calls all the time. I'm sure you do too, from kids who are just like, my life is over. They've seen this on TV. They think they're going to go to prison for the rest of their life or something for like a simple shoplifting. And I always have to talk them down and say,
hang in there.
Exactly. So
we got you.
Yeah. So how does it generally go for, like, if you're a college kid with the first time shoplifting, or, even something as serious as an OUI or assault and battery, is their life necessarily over? Or how do we get people out of that?
Yeah. I mean, like you said, there are a lot of options. So if it is a triable case in that, the facts are good, the person is either genuinely innocent or it's just too tough for the prosecution to prove, then that's something we want to take to trial and get a not guilty on. Because you get the not guilty, that record's immediately sealed. It's not on your criminal record anymore. And the not guilty is sort of like the ultimate absolution, right?
Yeah.
But not everyone has a great case. I mean, especially people who just get caught red-handed, they don't have triable cases, and you are not going to get the not guilty. And in those cases, the best outcome is going to be trying to get either this pre-arraignment diversion, a general continuance, or something like that, where the case is going to be dismissed before you either have to take a CWOF, a guilty plea, or go to trial and likely are found guilty. So if you have a bad case, you definitely want to do everything you can to get a general continuance. I know we've talked about it in the other podcast. General continuance basically puts the case on pause. And if you don't get in trouble for a certain period of time, sometimes there's conditions like you can't get in trouble and you have to do community service, but you complete the probation period, and then the case is dismissed. And that's a great outcome as well. And it's better than the CWOF because you don't have to admit to facts sufficient for a finding of guilty.
Yeah, definitely. And so general continuance, another term is pretrial probation. I've actually, in some course, if you ask for general continuance, I'll have no idea what you're talking about. Another course, if you ask for pretrial probation, they'll have no idea what you're talking about.
Right.
And I know we talked about continuance that a finding. So we call it CWOF. And I feel like we do this every episode because it comes up so often. But what does CWOF stand for and what does it mean?
CWOF is continuance without finding. And essentially, so you got not guilty on one hand, and then you got guilty on the other. And in the middle, there's something called the CWOF, which is you go into court and the prosecutor is going to read the police report. And they're going to say, Citizen X did Y and Z on this date. And then the judge is going to turn to the defendant and say, hey, is that true? And the defendant has to say yes. What the prosecutor just alleged in the police report, that's true. And the judge goes, okay, you say that's true. All right, well, if you say that's true, then I could find you guilty right now and sentence you to whatever I want. But you know what? I'm not going to do that. I'm going to put this on pause and we're going to put you on probation. And if you complete the terms of that probation, and it can be anything, it can be community service, it can be restitution payments, it can be the completion of an alcohol education program, drug treatment, all these different conditions. If you complete them, then your case will be dismissed. However, with the CWOF, if you violate those conditions or you don't complete it, then they can bring you back into court, and then the judge can say, all right, well, I put the case on pause. I tried to give you probation. You violated it. So now I'm going to sentence you. That's what can happen with the CWOF.
Yeah, exactly. And the judge can say, they can sentence you up to 2.5 years.
Yeah, you don't get a trial at that point. There's no trial. It's just the judge, hey, this is what you're getting. I gave you your probation opportunity. It's done. And that's different than pretrial probation and general continuance, because let's say they give you the general continuance and they say you need to do 12 hours of community service. If you don't do that 12 hours, the judge can't just sentence you. They just have to restart the case. And then now you're on the trial track again, where you can still go to trial, but you just lost the opportunity for dismissal. Whereas violating the terms of your CWOF can lead to immediate sentencing, much more serious. So you really need to understand the difference between a general continuance, that sort of probation with nothing at stake, and the CWOF, which requires an admission to the conduct, whereas the general continuance doesn't. And if you violate the CWOF, essentially you are found immediately guilty in your sentence. So
you
two
could
very
be.
different things.
Yeah, exactly.
Can be.
The biggest thing about a continuance that a finding, though, for our international students is that it's just the same as a guilty. So
yes,
federal immigration law says you have to have 2 elements for a conviction, an admission and a punishment. And basically, if they have both of those things, even if the state calls it a continuance that a finding, it's a conviction. So like for an international student, when you're looking at in this situation, there's something called a guilty file, where you admit you're guilty, but they put it in a file for a period of time. And after that, nothing else can happen. That can be potentially considered not a conviction for immigration purposes. But
really?
A lot of people get stuck. But even like a fine, a guilty fine, like guilty fine $500, conviction for immigration purposes, guilty.
Well, you know what's crazy too? I was looking this up the other day. Nolo contendere, which is you're just saying like, I'm not contesting this, but I'm not saying I'm guilty. Yeah. I'm not, I just say do whatever you want to me, but I'm not making an admission. That counts as a conviction. It says it in the statute. They say, if you say nolo contendere, you're not getting around our rules that way. And I don't know how that makes sense. I feel like they should challenge that, but that's wild. It's like, how are you, whatever.
So yeah, I mean, obviously we can't go, but Phil pulling out the Latin, is that the same as no contest? I feel like we don't have that in Massachusetts. I've never heard of it.
That is the no contest.
But you just had to
it's an absolute right. That's a common law right.
To plead no contest?
Oh, yeah.
Oh,
that goes back to ancient England, right? Legal history podcast coming out, folks.
Yeah, Bill's got to do his legal history podcast.
It's coming.
I think that might even put Chris to sleep.
It's all right. It's all right.
So, yeah, we're not going to go over the whole criminal process. We got a bunch of other podcasts. Episode 7 talks about the stages of criminal trial. You and Chris did a great job of going through all of this step by step. Episode 3, Clerk Magistrate's hearing. But a lot of times the criminal process itself is almost the least of a person's worries if they're an international student. Like, you get a clerk's hearing, it's dismissed, everyone goes home and celebrates, and then you get a letter from your dean, or then you get a notice of your SEVIS being terminated. Or is it SEVIS or SEVIS? Which one? Or is it, I heard it both ways sort of thing?
Tomato, tomato, you pick. You know what I mean? I don't know. I don't know who's the official SEVIS authority, but I haven't heard the president say it. So I don't
know. So a lot of times international students are what's called an F1 visa. And you and Chris did a great job of going over this in episode 8. But just let's kind of bird's eye view for people who don't have the time to really go over it and are scared to death about getting a letter in the mail. First, about the criminal justice system. A lot of times, if it's a minor misdemeanor, your life's not ruined. You're not going to go to prison and anything like that. Really, where you have to worry about are these next 2 areas. So if you're an international student, what are the risks for getting a criminal case?
Right. So it depends on what that criminal case is. So like you said, if it's sort of a petty misdemeanor, there won't be a lot of consequences in terms of your visa being revoked or anything like that. But if it is, let's say it is a crime of violence, and that's a term of art in immigration law. If it's a crime of violence or a crime of domestic violence, where there's a serious injury, that will make you immediately deportable. So you have to watch out for, convictions like that. But like you said, in terms of the most likely repercussions, it's probably going to come with the school. And the scariest thing about the school systems and how they can handle these situations is that it's kind of a free-for-all.
Yeah, so I want to talk about the immigration stuff just a little bit more before we get into that, because I do think it's really important, especially with our climate today, where I mean, you and Chris talked about people's, like, even getting charged with something, even facing an arraignment, even being arrested, goes into the DHS system, the Department of Homeland Security, ICE, can result in your right to stay and study being terminated. And there's, you and Chris talked about the difference between an F1 and if you're an OPT and things like that, and how that process works. One thing that I think is also important to talk about, though, is that if you get a criminal case, even if you complete your school, that could affect your eligibility for a green card down the road, could affect your eligibility for naturalization down the road as well.
Right, because the good moral character requirement.
Right, exactly. Which is pretty wide reaching as far as what they can look at and what they can, see.
So it's sort of like the suitability. We just covered this, but so there are the automatic prohibitors, right? Where so if you're convicted of this, automatically deportable, or you're automatically going to have your visa revoked, or you'll be considered inadmissible. But even if you don't have the automatic disqualifiers, you can run into the good moral character issues, right? So like if you weren't convicted of a crime of violence, but you were alleged to have committed a crime of violence, same thing, they can look at the police reports, right?
Exactly. And in immigration court, unfortunately too, like they get these police reports and they're gospel. I've had people who have been facing removal proceedings for things that haven't even gone their way through the criminal justice system, and they're facing immigration detention, things like that. Hopefully our college students don't get in that much trouble where they're looking at it. But there is that immigration angle too that you and Chris did a great job of covering in episode 8
Yep.
for the international students in terms of this is also a risk area. So let's
absolutely.
So even after, you know, the criminal case, even after the immigration stuff, kind of have the triple whammy of the student discipline. So you were saying it's kind of a free for all. What do you mean by that?
Yeah, I mean, the scariest part is that you go to the clerk magistrate hearing or the district court. They have rules of evidence, rules of procedure. Right? Even in immigration court, they got rules. Okay, you know what you can and you can't do, and they have checks and balances in terms of who's hearing evidence, who's deciding on the credibility of the evidence, XYZ. People have constitutional rights, right to an attorney, right to cross-examine. And when it comes to schools, that all goes out the window. It's literally just whatever they want. And they try to come up with guidelines and handbooks. But at the end of the day, it's just kind of however they do it. And I've seen cases where, a student's entire career is on the line. Their entire admission to the university is on the line. And the 3 people making the decision whether or not they're going to have their life ruined are 3 undergraduate students.
Yeah.
And there is no like review. There is no, right to an attorney. I've actually had handbooks explicitly say you are not allowed to bring an attorney.
Yeah. So let's talk about that, like the attorney role, because I feel like I've represented people in these hearings where I'm allowed to basically do the whole thing, like cross-examination, direct examination, opening, closing statements. And then other times where I'm supposed to be the advisor. Like I literally had a Zoom or WebEx or whatever, like one of those. And I was sitting next to my client, basically telling him what questions to ask and what to say, because they have to do it. I'm only there as an advisor.
Right.
So, yeah. And like you said, then there are some that just don't allow you to have an attorney whatsoever. Every school has different rules.
Every school has different rules. And I mean, even how they're applied can be very, patchy at best. And the other issue is how this interacts with the criminal justice system. I mean, a lot of students will sit in the student meeting and be like, well, I'm innocent until proven guilty, beyond a reasonable doubt. Well, that's not how it works for a lot of the universities. Honestly, all of the universities, because, I don't know if it's liability or just, they want to hold people accountable. But if they even get a whiff that you've done something illegal, they will just act as if you have and punish you accordingly. They don't wait until you get a guilty verdict. They don't. They just punish you. They just listen to the evidence. There isn't, some standard. There's no beyond a reasonable doubt standard. I mean, they may say, preponderance of the evidence or whatever, but one person making a decision, they're going to make the decision they want to make. But so, for instance, in these fake ID cases, right, I've had it go both ways where the students have their disciplinary hearings before we've even done the clerk magistrate hearing. So the clerk magistrate could say, oh, yeah, no, this was a complete mistake. Yeah, we got the wrong person. But, the college doesn't wait to hear that. The college just says, oh, we heard that you got summons to this somehow. And, hey, I don't know how these colleges find out exactly. Topic for another day. But they find out. I promise you, your university is going to find out if you get summons to a clerk magistrate hearing. And they just say, oh, okay, so you must have done it. And then they do their hearing real quick because, they have a ton of free time. In the court, ours is a little busier. So your court date may be 3 months in advance. And by the time you walk into court, you've already sort of like got your punishment from the university.
Yeah. And I mean, it can be anything from like a written warning to expulsion. And like, it's so funny because they have all of this in the handbook. And I've done these at a bunch of different schools, and they vary a lot in terms of their detail. But it's funny because you mentioned the rules at one point, and I had one case where my client there was like 3 stages to the hearing. Like there's one where you have a meeting with an associate dean and they sort of say, they talk to everyone and they say, yep, here's your punishment. And then you have the student review hearing where you have, like you said, the 3 students, and then you have the hearing with the dean if you don't agree with that. And after the first hearing, they were like, yep, you're suspended, you got to go. And I was like, no, it doesn't. It says in the student handbook that it stayed if we appeal. And they were like, well, it says in the other part of the student handbook it's not. I'm like, well, which one applies? Like you have 2 different standards in 2 different areas. And it's like,
and the issue is, who do you appeal that to?
Right.
Because it's themselves.
Exactly. Like
we conducted a review of our process and it looks good to us.
Exactly.
Okay. All right.
So yeah. And that's the thing, is that there is, like, I guess, some minimum of due process. Like you have a right to be informed of the allegations. You have a right to be heard. But that's probably about it in these hearings. Like,
well, and another issue I want to talk about that pops up is that, so I was mentioning the timeline of when this stuff happens. Well, I have a client who is, their university wants to wrap up the whole investigation like right now, but we're still in the discovery phase, and we're, thinking of trial still a few months out.
You mean in the criminal case, you're still in the discovery?
In the criminal case.
Yeah.
Yes, sorry. So there's an open criminal case and we're in the discovery phase and trial's still a few months out, but the university is like, well, we want to wrap it up now. And we're in this crazy position where the university says, hey, you need to defend yourself completely right now or else we may expel you. But everything you share is going to be given to the complainant, like the person who complained about you.
And through him or her, the complainant gives it to the DA.
To the DA. And so basically we're in this weird position where everything we want to do at trial, to like all the exculpatory evidence that would show my client's innocent, we have to give that, either have to give that in advance, and now the DA knows about it. Everyone knows what our trial strategy is. There won't be any surprises. Like, so let's say one example is impeachment material. Like I have a piece of paper that says this guy is lying about my client. Now, I want to save that for trial so that when he goes on the stand at trial and he lies, I nail him with that piece of paper and say, hey, how come he said something different this time? But in order to try to have my client avoid university punishment, there's a pressure for me to give that impeachment material over right now. And if I give that to the school right now the person in that criminal case knows what's coming.
Yeah.
So it's, very unfair that these universities they will not wait until the end of the criminal trial.
So you can't like file a motion to stay and say, hey, can we wait until the criminal trial is over? Because that's the thing, is that in a criminal trial, everyone's heard the Fifth Amendment. I plead the Fifth. You have a right not to testify. You have a right not to be compelled to present evidence. All of those sort of things. And certainly they can't force you to testify in the school discipline case, but they can hold your silence against you.
They can certainly hold your silence against you. And they can just say, oh, well, if you didn't respond to it, we're going to assume it's true. And we're just going to punish you accordingly. Right? Like you had an opportunity to come in here and show evidence that it wasn't true, and you didn't. And so that's what's perverse about this, in that you might be doing the correct legal strategy, which is to, hold your cards close to the chest so you can win at trial. And yet your university is trying to punish you for that.
Yeah. It's like you have a choice. Do you want to have the best defense at your criminal trial, or do you want to have the best defense at your school discipline?
And that is the problem. That's the fundamental issue that is just inherently unfair to students. And, I don't know, I guess universities just have pressure to close the cases and to do something about it. Like, need to do something about it, because they don't want to hear, like if the student punches someone else, let's say, or it does something else, they don't want to get sued by someone saying, oh, well, you knew this person was a problem and you didn't even punish them or do a judicial review for 8 months, for 12 months, because that's how long it may take to do this trial. I mean, I can tell you that for the client I'm speaking about, it will be over a year since the initial date. So it doesn't make sense the way the schools treat these things.
Yeah, and like you talk about the Fifth Amendment, you don't even have like the right to cross-examine. Like I did one of these student review hearings, and you were there actually. We were given the initial paperwork we couldn't actually take it. We were given the initial paperwork of the investigation to review, and I don't even remember whether we could take notes. And we didn't have the right to cross-examine this guy who said this. We could present our own evidence if we wanted to, but we didn't have the right to hear it from him.
Mm-hmm.
But then after that associate dean or whatever said, you're suspended, we were given the right to the student hearing, and the guy was there. The guy like gave an opening statement. He like gave his side of the story. And then when it came time for my guy to ask him questions, he was like, sorry, I got to go to practice. Bye. I'm not sitting here. I don't think this is worth my time. It's been 2 hours already.
Ridiculous.
Like it's only about this guy's suspension, like only about this guy's career. Who cares? And we were like, hey, we have the right to ask him questions. We want all of his testimony disregarded. And the school was just like, yeah, I don't really care what you want. Like, we believe him.
Right.
It's just like, can you imagine if that happened in a criminal trial, Bill, and like the police officer gets up there on the stand and says, yeah, here's what happened. Your guy was drunk. He was driving, and I got tea time. Bye. Before you have a chance to ask him questions, what does the judge do? The judge doesn't say, well, close enough.
Right.
The judge says his testimony is stricken. You have a right to cross-examine him. And none of that happens in these school hearings.
Oh, because these schools, they don't care about the Constitution, Matthew, right? All right. Jeez.
Yeah. So you kind of have this triple whammy if you're a student of the criminal charge where you have constitutional rights, immigration where less constitutional rights, and then the student discipline where it's just like you never know what you're going to get. Like I've reviewed plenty of the student handbooks around here for different cases, and I can tell you, like, it doesn't even have to be a neutral judge. Like in some schools, they do. They actually, in one of them, they hired a lawyer from a law firm, like an independent lawyer, to conduct the hearing. But in a lot of times, it's just like students. It's just, whatever.
Right.
It's an associate dean, whatever.
Mm-hmm.
But yeah, and then you have the student discipline, which is just, like you said, kind of Wild West.
Yeah.
Mm-hmm. It's kind of like, what's the show? The points don't matter. Whose line is it anyway? Oh
man, that's a throwback. Whose line is it anyway?
That's still on, man. It's not that old.
Yeah, on the old people TV channel. Yeah.
Yeah, it's like when I tell our immigration clients about the Newlywed Game, and they're just like, "What are you talking about?"
Yep.
I mean, that's even old for me, to be fair. But yeah, so we kind of have this. If you're an international student, like, and you get one of these, and the other part about it too that I wanted to talk about is that if your student discipline involves your suspension or your expulsion, then what happens to your visa?
Right, exactly. It gets revoked because you're only in the United States to study. You're not allowed to work on a visa. You're there for education. So if you get kicked out of the university, you've lost your status. And that's not good. That's not good.
Yeah, definitely. And who knows, like, even if the university wants to let you back in, who knows whether you'll be able to get status to come back in, different things like that. Like, I mean, I can tell you from student discipline, we talked a lot about how the negative parts of it.
Mm-hmm.
I mean, it really depends on the school, because I can tell you there are a couple of schools around here who really do take it seriously and who really do, conduct meaningful review at each stage, and who will look at it and say, yeah, this guy's accused of doing something bad, but he has rights and he has like protections according to this. It just really depends on the school. And this isn't something that you know going in, right? No one looks at the student handbook and sees, well, what happens if I punch a guy? Right.
Yeah. I don't think there's a U.S. news ranking for like best student judicial system, is there?
I don't think so. I mean, so yeah, if you're a student like and you get in trouble, you know, we've talked a lot about the bad, but you know, can you give the people some hope here, Bill? Like if you're a student and you get caught up in this, like, you know, what kind of hope does somebody have?
Well, I'd say step one is hire an attorney because you want to look like you're taking it very seriously. And I think something I talk to my students about, especially with the fake ID hearings, is you need to take this very seriously and you need to look like you're taking it very seriously. Because as soon as, you know, a school administrator or a clerk gets a whiff of you just like, oh, yeah, like, I don't care what happens. This isn't a big deal. Like, I don't care. I'm a privileged 20 something. They want to bring the hammer down on you.
Oh, yeah.
Because that attitude is exactly what they don't want. Because a lot of times in these fake ID cases, they may give you a break, but they give people breaks who are like repentant and who take it on the chin, say, yeah, yo, that was totally a mistake. I shouldn't have done that. It won't happen again. They'll give space to people like that. You go in there by yourself and you don't have an attorney and you're wearing a t-shirt and you're like, what's the big deal, man? Like, people are drinking all the time. Don't do that. All right. Same thing with the student discipline stuff. I mean, you show up in a suit with an attorney, you're telling the school that you're fighting for your career, your life, and that, hey, I'm bringing the big guns in here. So don't try to slap me around like you may with these other kids. All right. I'm serious. And I think just bringing that energy, bringing that attitude, people will take it more seriously, right? They will investigate further. They will think twice before bringing down the hammer on you if Matthew Peterson is sitting next to you, right? Because they know that Matthew is going to be scrutinizing every single decision you make.
Yeah, looking at the student handbook and finding the contradictions.
That's right. That's right. And, you know, sometimes these school administrators, they don't want any of that smoke, right? So they might be like, all right, hey, you know, whatever. Probation, like, good job with the attorney. All right, get out of here. So I think just kind of showing up like that, showing everybody you're serious, that's like the best step one. And there is hope because I will say, as you said, some schools, they do want to work with you.
Yeah.
I've had phone calls with investigators who tell me, yeah, you know, if you want to submit evidence, do that. But I'm still running into the same issue, which is, you know, do you want the best trial defense or do you want the best school defense? And that they, no matter how much they want to help out with that, unless they're willing to pause the school hearing, there's really nothing they can do.
Yeah, definitely. And I mean, we've represented a lot of people who were looking at, you know, called us with very serious issues like, oh, I mean, I don't really want to sit here and give examples, but, you know, and it just looks hopeless in the beginning. And then by the end of it, you know, they're still graduating. They're still, you know, able to go to class. Like we're able to craft something with the school to satisfy the school, but still help our student be able to move on.
Yeah. And that can take two different forms, by the way. So it may be a case where we're in there fighting for you saying there's no probable cause, there's no evidence, there's no corroboration. This is absolute crap. Drop it now. Some cases are like that. We like those, right? But sometimes it's more of a like, hey, yeah, this wasn't great, but, you know, this is a young person, you know, frontal lobe not fully developed, right? We all make mistakes, and let's look at the broader context here. This is a person with no criminal history. Right.
So,
like great resume, all of that. And we're doing more of a leniency approach as opposed to the justice.
Yeah, see, that's the kind of lawyer you want. You want a lawyer who knows the absolute crap defense and also what nolo contendere means. You know, it's in the same podcast. But yeah, exactly. To your point, like we are, sometimes that's the best strategy is not to, in a criminal case, like, a lot of times I want to go when they're guns a-blazing. You're a liar, you're a liar, you're a liar, that's unconstitutional, dismiss the charges, all of that, like, tear the prosecutor a new one, then tear the judge a new one, then tear probation a new one, all of that. But other times the best course of action is just to say, listen, you guys at the school, you have an interest. You want to make sure everyone's safe. You want to make sure everyone feels safe. Everyone's protected. No one's discriminated against. No one's, uncomfortable in certain ways. Let's figure out a way to make that happen. Let's figure out a way to make that happen while my guy still gets to complete his studies. My guy's entire career isn't ruined. So sometimes that's the best approach too. And you got to have somebody who will see which approach it is, the absolute crap or the nolo contendere. Right.
Right. Exactly. Yeah. Cause I mean, at the end of the day, a lot of these universities, they are putting out products and their students are the product. And so, if you're shooting yourself in the foot, getting all your students caught up in disciplinary hearings, and then that goes on their record, they're not going to get hired. And if you can't brag about how your senior class just got hired at all these Fortune 500s, you're not going to get the admissions that you want. You're not going to get the funding that you want. You're not going to get that U.S. news ranking, right? So there's a lot of angles. There's a lot of angles you can take to help the school see the bigger picture.
Yeah, definitely. So I think there's a lot of range there as far as advocacy in different areas. Even if you can't actually appear, you can help your client draft their statement. You can help your client figure out what evidence may be out there and sort of try to gather that evidence. We've helped people investigate cases, be able to get videos and documents from other sources, things like that. So even if it seems hopeless in the beginning, and even if it seems like you have no rights, there's still a lot of fight out there for you to do. Even if you're, stone cold guilty, and even if it seems like there's no hope, like there could be technical arguments, there could be, mitigation out there that you really want to explore.
Right.
So,
and you guys are busy, you're taking your courses, you got exams. If, you hire us, I can spend all day putting together a beautiful presentation with all the evidence, right? That's just hard for people to do on their own when they're students, like you have full-time obligations. And a lot of the times is you have good information, you have good evidence, but it's hard to marshal it, to compile it in such a way that it's easy to understand for a judge or a school administrator.
Yeah.
Because you have limited amount of time and both sides are, saying all these things about the other side. And sometimes who wins is just who explained things more clearly and who sounded less insane, right? Like you don't want to go up there and just ramble and he did this. And, last Friday, I wanted to go to TGI Fridays, but we had to go to Chili's and blah, blah, blah. It's like, you gotta know what information to present, how to present it, and do it clearly,
Yeah, exactly. And I feel like that's a lot of times where a lawyer gets involved. But you might not know what makes you special and what is unique about you in a way that can be presented to somebody in a compelling way. You may not know what's important and what's not important, whether it's Chili's or TGI Fridays. I don't think Chili's is still around, are they?
Oh, hey, Chili's is coming a major comeback, like top of the rankings of fast food chain. I haven't been.
It's not a fast food chain. Like, come on.
Not fast food. Like, what do they call that? Like fast casual or something? Like, I don't know. But it's Chili's, they had their down period there, but apparently because fast food, the cost went up so high, now Chili's is like good value. It's like, oh, $2 more, but I get all this other stuff. And I don't know, not going to distract anyone, but you can Google that, the rise of Chili's in the past year too.
See, so you come for the fake ID discussion, but you really stay for this discussion at Chili's. I feel like.
Heck yeah. Yeah.
That's the kind of analysis we need.
Yeah. And I haven't heard of Chili's taking away fakes. I haven't heard of that.
Oh man. I'm gonna leave that there, Bill. All right. So yeah, international student or student in general, if you get in trouble, there's a lot of hope out there. There's a lot of ways you can fight back. The important thing is to get somebody on your side you can trust and who can help you navigate all three areas here: the criminal, the immigration, and the student discipline. Yeah, I think we'll end it there, Bill. Thanks for that. That was great discussion. I feel like we gave a lot of good information to people out there who are facing this. And if you have any more questions, drop them in the comments. Maybe something that we can do. Bill can record one of his famous shorts on.
I got you.
Or
hey, you guys got questions, requests? I got you.
Yeah. Or if you have something that you want to discuss privately, our number is on here somewhere, I think. Or maybe Jazz can put that up in post right
if you're
here.
If you're in a spot and you need a hammer or you need a shield, whichever, we're here. All right.
Hammer or shield. Whichever, I guess. Or sword or shield. I don't know. Hammer.
Sword or shield. Well,
you're mixing metaphors.
Whatever you need. All right.
All right. Well, that was a great episode 12 of Boston Barristers. Really focused on the international students and students in general and what happens if they face a criminal charge. Thanks for coming on, Bill. It's a great discussion, and we'll see you on lucky episode 13 of Boston Barristers.
See you guys next time.